Good morning, Chair.
Good morning, Mr. Buthelezi.
Thank you, Chair. As my learned friend has prefaced, Chair, I appear before you this morning to request a postponement of the appearance of Ms. Myeni. And the reasons behind that, Chair, I'm at first at pains to stress that it's not an indication of reluctance on her part, and ultimately the issue can be reduced to a breakdown in communication. Now, Chair, where we start with this issue.
Of course, the first thing is for you to indicate whether you confirm that she is not here despite having been served with the summons that required her to be here this morning.
That much is true, Chair, I confirm.
Yes.
Sorry, Chair.
And is the reason why she's not here the same reason why you asked for a postponement? Because in terms of sequence, I should first be satisfied that this is not defiance, because the question may arise as to why should I even hear an application by her for a postponement when she is in defiance of the summons and of this commission? Because one would expect that if she has a legitimate reason for a postponement, she would appear and say, I'm here in compliance with the summons, but I am applying for a postponement for the following reason.
Indeed, so, Chair.
So you can deal with that.
In dealing with that, I'll go to the paragraph that Ms. Hofmeyer quoted
Yes.
from the letter that was delivered on Friday, 21st,
Yes.
which reads as follows. We therefore request that the Commission stay execution of the summons for our client to appear on 25 May 2021, as we need to first have a benefit of your responses to all the above before advising our client accordingly. Now, Chair, I don't know whether it's fair to the attorney, but the Commission did respond around after 9 p.m. on Friday evening. And I've shown this to Ms. Hofmeyer. The attorney sent me the response at 10 p.m. last night, saying he only saw this email at 4 p.m. Now, that's not for the Commission to rectify, or it's no fault of the Commission. The Commission did respond. What subsequently happened with the attorney not picking up or not communicating to the client was under the bona fide impression that the request for a stay of execution of the summons, pending the response from the Commission, would have then been accepted, or no response had come through. So, to deal with your point of defiance, Chair, I point out to you that first, it was requested of the Commission to say, we have a certain view with regards to the correspondence that you sent. Now, at the start of that letter, it starts as follows. It says, we place ourselves as attorneys of record in the matter concerning Ms. Myeni, as she had ceased being represented by Mabuza attorneys since early April. Further evidence of that, Chair, is confirmed by the fact that how this correspondence now for this appearance got to Ms. Myeni was through the Commission contacting her directly after not receiving any responses from Mabuza attorneys. And the people at the Commission were aware that they had to then contact her directly, and she then had to instruct new attorneys to pursue the matter. So prior to being contacted by the Commission, she was not aware. And the letter does say, as a result of the aforesaid, Ms. Myeni did not receive correspondence of 1 April mentioned in your letter, and has only come to know of the Commission's attempts to reach her in correspondence that was sent directly to her. And it is in that direct correspondence, Chair, that she took the steps and then appointed a new attorney Through an unfortunate circumstance, as I will illustrate, as I've stated, Chair, she and the attorney were under the impression that the Commission had not responded. And
In which case they should have taken the attitude that the summons stands and therefore she should appear.
indeed so, Chair, correctly so. And I advised accordingly yesterday, and I said, look, regardless of a non-response, you need to take the necessary steps to make sure that we do get here. And it was only then that I think a concerted effort for the email to be traced or somehow found, maybe it could have been lost in a heap of emails from an unknown address, that it was actually discovered that the Commission did respond. But due to time constraints, and as I showed Ms. Hofmeyer that he says he only picked up the email at 4 p.m. yesterday. And given that Ms. Myeni is not stationed in Gauteng, she was then of the view that, look, can you approach the Commission on my behalf and request a solution to say, how do we facilitate their appearance? In other words, is there still a prospect for this to be heard online or to be deferred to another date, either later in the week or early next week, or whatever workable solutions? But the one thing that is absent from all of this is a reluctance to appear, Chair. So it may inconvenience the Commission, and we apologize, Chair, and it may cause consternation, but in as far as it seeks to imply that there's defiance of the Chair's summons, I submit, Chair, that there is none. There's no such intention, and I think we have indicated by the last paragraph that says we request a stay of execution. In other words, we didn't take a point that says we'll just won't appear because we've written your letter. And in concluding that letter, we submit that pending your response so that we know how to advise clients accordingly. So, in as far as intent not to comply, I think that test is not met, to say, because I think there was intent, and in as much as we may want to impute that defiance to the client, I think there's some level of evidence that removes culpa from her, or maliciousness to that extent. Now, Ms. Hofmeyer had raised certain points, Chair, and I need to take these points because she glossed over them. The first one is that client was advised about the invocation of the privilege against self-incrimination. And we took the view that the test set by the Concord to the effect that would this privilege be applicable in criminal proceedings? Would this be a privilege that you would be able to invoke in criminal proceedings, yes or no? And I think that's the test. And we relied on the submission that we have already, in all matters referred to SAA, been referred to criminal investigation. And we say that the prospect then of self-incrimination is triggered by a court order. It's not in the abstract. Apart from it not being in the abstract, we also read the Concord decision.
I think let's separate the issues.
Yes, Chair.
Because that belongs to another phase.
Yes, Chair.
Yeah. Let's deal with the phase where we are. Is the position that if I direct that your client gives her evidence via Zoom or whatever link, she is ready to comply with it?
Indeed, Chair. The only issue would then become a matter of organizing it for when. But
well, I'm talking about
today.
Today. I'm not talking about another day. I'm talking about today.
I'd have to take direct instructions on that point, Chair. Because last my discussion with the attorney last night, we didn't have a clear indication of the state of readiness for client to testify in terms of one receiving those files, whether she'd be able to access whatever documents that the Commission would need her to work through. That's the only logistical challenge that there may be, Chair.
Yeah, because if from her side she did not mean to not to cooperate with the commission and didn't mean to defy, one could expect that because she knew that the summons required her to be here, she may be available if I approve that she be connected via Zoom or whatever link so that we can proceed, because otherwise the time might be lost. So maybe I should adjourn for you to take instructions on that, because depending on what the answer is, it may be that we might not need to be detained too long on certain issues. Of course, if we went that route, the question of her non-appearance here would be one thing, but if she is available and arrangements are made and we are able to continue, that might be another issue. So, but if the position is that she is not available, then one must take it from there. Ms. Hofmeyer, what do you think about that suggestion? I know he hasn't finished, I think. What do you think about a short adjournment for Mr. Buthelezi to get instructions?